Okay, everybody, it's 10 o'clock. We're going to go ahead and get started. If everybody wants to grab a seat, fill up your coffee, we'll get going. So welcome to Nebraska Savvy Seniors Empowerment Seminar. Today we have a powerhouse for you. We have three exciting guest speakers that are going to talk about wills, trust, and probate. Oh my. And I added the oh my on there because how many times have we thought, oh my, I need to do this. Oh my, what am I doing? So we're going to demystify all the things that you may or may not know about estate planning today and answer most of our questions. Before we get started, just want to welcome you to Nebraska Savvy Seniors. You may be wondering, why are we doing this? Well, as a realtor here in Lincoln, I specialize in helping people 55 and older with their transitions. And I'm finding more and more people are asking me about wills, how to avoid being a scam, how to downsize, all these other different questions. So in order to help them, we've developed these seminars, and they're free to come, and it'll help you answer some of those questions on some of these issues that are important to us as we grow older. So I welcome you, and about halfway through we will have a little bit of a break where you can get up and shake your legs, fill up your coffee, grab something to eat, and then we'll continue back. So as you're listening to our speakers today and our panelists, you do have a piece of paper. You can write down any questions that you may have, and if you want to ask those to the panel, or if you want to ask them personally during the break, you can. And I want you to make sure that you visit our educational partners. They're all located on the tables around the room, and these are the people that we can do what we do without them. They helped us, they sponsor us, they help promote us, and they are all companies that are vetted. They're personally interviewed by me to make sure that they are going to treat everybody, my clients, in the manner that they deserve. So, without further ado, I want to go ahead and welcome our guest panelists today, and let's give them a great big hand. And I'm just so excited to have these people here. We've got the top-notch people here, the ones that are experts in this field, and if they don't have the answers to the questions, then there are no answers. So we have Andrew Loudon, who's one of the foremost estate planning attorneys in Nebraska.
I'm friends with Kay.
And he's hilarious. He's hilarious. And we have Leslie Gibbons, who's a vice president at Union Bank, and she's in the wealth management department. And she's got a lot of different degrees after her name. And so she's an expert in a lot of different things, and she can help guide you in this too. And then we have Dave Koenig, and he's also a vice president with the Union Bank and Trust in their wealth management department, and he specializes in developing relationships with people, and that's what his forte is. And he's a brainiac when it comes to all these kind of estate plannings and trusts too. So we're going to find out what are wills, what's probates, what's a trust. We're going to figure out what the differences are and what it is that we might need. So without further introductions here, you want to check your mics and see if they're working? Might need to turn on. Is that yours? Yours going, Dave?
Oh, thanks.
Hello.
Okay, he's got it. All righty. So if you want to just, do you want to add anything to this? Tell us more about yourself, about your business, why you do what you do. Just give us a brief introduction on how this is your passion.
You bet. So again, I'm Leslie Gibbons, and just had an anniversary. I don't know where the time goes. I've been at Union Bank now for 23 years. And my position is the perfect coupling for my strengths and interests. Started out in nursing, and then realized what really interests me is a good spreadsheet. So I went on and completed the CPA exam, and now I like to say that Doug and I are the front doors into the trust department. So we get to work with individuals and their team of experts as they are working on their estate plans, putting their wills their trust, their power of attorney documents together. And at Union Bank, we believe that the relationship is what is important. So we want to get to know our clients and understand what their goals are, be a resource to them as they go through the different stages within their lives. So happy to talk with everybody today.
Yeah, and just hold that mic a little closer so they can hear you in the back.
Well, my name's Andrew Loudon, and I've been a lawyer for 25 years. And the only type of law that I practice is estate planning and estate administration, which means that on a day-to-day basis, I work with people while they're alive to help plan for what happens with the transfer of wealth at death. And then the other half of my day is estate administration. That's now more than half of what I do. That's when the rubber hits the road, when people die, and we see whether things go as planned. And I've learned the most about what people should and should not do during their lifetime by seeing how things sometimes play out poorly or not how the person intended after that person died. So our goal as a group here is an educational one. We're not here to solicit your business. If there are questions that you have, you should go back to your attorney, back to your financial advisor, back to your accountant, and hopefully this will arm you with some good questions for your professionals to make sure you're handling everything correctly.
And I'm Doug Koenig. I've been at Union Bank for 22 years. Had experience with investments and insurance a little bit before doing what Leslie and I do. So we do the same thing at Union Bank, and really it's administration of trusts and estates. So we don't draft any documents at Union Bank, but we're there to follow the instructions that you guys put in place. So we need people like Andrew for you to work with to create those estate plans with those good instructions that eventually one day we can follow. So, and we're referred to as a corporate fiduciary. So, as we talk through this a little bit, you can name certain people to have certain roles in your estate plan. And another option is to have a corporate fiduciary in there as well. So.
Okay, great. Well, and if you guys could just kind of basically describe to us what's the difference between a will, a trust, probate, where do they fit in, and what's the similarities, and what might be the differences in those. And these three have done seminars, and in fact, they just did one yesterday. So
We're on tour.
Okay, we're on a roll. So instead of gearing the questions to anyone specifically, you guys know each other, you know who can answer these questions better, and so I'll just let you, whoever wants to take the mic for these questions, take it.
So the first thing that we were asked to talk about is what's the difference between a will and a trust? And this is the number one question that we get from people when we meet with a new client. They say, what is a will? What is a trust? There's 100 different ways to do estate planning, but big picture, there's really two main ways. One is using a last will and testament, and one is using a revocable living trust. And with every new client, I describe the differences between the two and the pluses and minuses of the two approaches. So I'll do that for you right now.
Okay.
So a will is the old-fashioned way to do estate planning. There's nothing wrong with a will. Like so many things in our society today, this is a generational topic. If you asked your average baby boomer attorney, he, and they're mostly men, would say, keep it simple with a will. Your parents had a will. Probate's not that bad. If you ask your average millennial attorney, and I've got two awesome younger law partners who are millennials, she, and most millennial attorneys are women, would say, probate's for the birds, everyone should have a trust, don't go through probate. Proving that I'll be 52 years old this year, and I'm a Gen Xer, I can see it both ways. So I really can, and they say that's about Gen X, is we understand both the boomers and the millennials, but the boomers and millennials don't understand each other. So we're bridging the gap here.
Yeah.
It's really true. And so the benefits of a will, what is kind of the old-fashioned way to do it, is number one, it's simple. And I have a lot of clients, regardless of net worth, who come in and say to me, yeah, I know that a trust is probably a good idea, but here's the deal. I want you to give me a 3-page document and no more. And I don't want all those fancy words in there, so keep it simple, Andrew. And I can do that with a will. I can keep it very simple. And that, if that's the client's goal, we can do it. Another advantage of a will is it can be one and done. You know, it's a good idea to review your estate plan every 3 to 6 years. That sounds self-serving when a lawyer says it. And I have clients who say, yeah, I know that's true, but here's the deal. It's not gonna happen. I'm just gonna do this once. I'm getting ready to retire, and I'm not gonna think about this ever again. Which I appreciate if the client is honest about that. So then we usually steer those folks to a will, because all the work with a will happens after you die. So you really can just keep it very simple, do the will once, put it in the safe deposit box, and then everything happens after you die. The final benefit of a will is, for most folks, it's going to be less expensive on the estate planning side. So that's the will. All right, now what's a trust? A trust is, it sounds weird, it's a contract that you make with yourself. It's like an LLC or a corporation. There's a lot of business owners in the room. I know from having spoken with a lot of you beforehand, that's a good analogy. It's very similar to an LLC or a corporation. It's an entity that you create during your lifetime. I describe it as a bucket that you put your assets into while you're alive. That's why some people call it a living trust. You create it while you are alive. You put those assets into that trust, and then the reason you do that is after you die, then if done correctly, we avoid going to court through what's called probate. Because you see, in Nebraska, if you own $50,000 worth of real estate in your own name alone, and folks, every house in Lincoln, Nebraska is worth at least $50,000, or you have $100,000 of cash assets without a beneficiary. If one of those two things happens, you have to go to probate court. And it's usually after the second spouse dies. After the first spouse dies, it can be as simple as, if you own your house as joint tenants with rights of survivorship, filing a death certificate with the Register of Deeds. Now the house is in the name of the surviving spouse. Usually spouses own bank accounts jointly. Just go to Union Bank, show them the death certificate, the survivor's the owner. Same thing with the DMV in your car. Take the death certificate down there. You don't need a lawyer for any of this. You can do it on your own. And usually spouses are the primary beneficiary of life insurance or retirement accounts, things like that. So the probate usually happens after the second spouse dies. And I always joke with clients, mom and dad, you know, mom and dad, you're never going to be worried about your own probate. Ha ha, because you're dead. That's true. That's one of my few jokes, since our topic is always death. But it's true, you'll never be worried about your own probate. But guess who will? Your kids or your beneficiaries or your nieces or nephews. And so most of our clients prefer to use a trust, and the main reason, there's lots of reasons to use a trust, but the main reason is to avoid the court system at death. Because if your home is owned by your trust, if your investments are owned by your trust, if your personal property is owned by your trust, when you die, there's no need to go through the court system. There's a myth out there that if you have a will, you avoid probate. That's false. It's only if you have a trust that owns your property that you avoid the court system. Okay, why would we want to avoid probate? What are you even talking about? Why is that a good thing? I know because I do a lot of probate work. Tons of people come to our office because their parents didn't have a will. That's the majority of people. I won't ask for a raise of hands, but I know there's people in this room that don't have a will. And if you died and you own a house, there's a probate. Or if you just have a will, you don't have a trust, there's a probate. And I hear from the kids, they're like not happy. And they're like, even some of my friends who come in because their parents died, they're like, no offense, Andrew, but I'd rather not be here and pay you a bunch of money just to transfer my mom's house. This doesn't feel very good. So there's three things that kids do not like about probate. First and foremost is my profession. Lawyers charge handsomely for probate. Some lawyers charge more handsomely than others. In our office, after someone dies, we only charge on an hourly rate basis. Many lawyers will actually charge a percentage, 1 to 3% of the value of the estate as their fee. That's why a city kid who went to Lincoln East right across the street, go Spartans, that's why we have hundreds of farm and ranch clients, because these are sophisticated business people who aren't about to pay the local attorney 3% of the value of their farm. We just set a record in our office again last month, sold a farm in York County for What are you gonna guess, Senator Hudkins? $17,000 an acre for prime irrigated farm ground near York, Nebraska. Do that math. And so you don't want to pay 3% of $17,000 ground. The total sale price for a pretty typical farm is about $10 million. And so we're talking big bucks in ag land. So every farmer and rancher wants to avoid probate for that reason alone. But there's two other reasons to avoid probate. Reason number two, I think this is a bigger deal if the lawyer charges correctly, is efficiency. Probate takes too long. It takes about a year. And I always tell clients, don't shoot the messenger. I can't control the judge's calendar. We have a dedicated probate judge in Lancaster County. Her name's Holly Parsley. She's super nice. She was a year ahead of me in law school. We're buddies. She is so far backed up. The last 2 times I've been in probate court, she was an hour and a half behind, because you see how many people are in the obituaries. Her docket is super full. It's getting backed up by weeks. It takes about a year to have the probate process go through our court system. If you have a trust, your kids can automatically transfer your property. They're done in weeks to months instead of a year. To me, that's the number one benefit of avoiding probate and using a trust. And the final benefit, which may or may not be important to people, is privacy. Probate is a matter of public record. When you admit that will and you admit the inventory of the assets, that is available for the public to see. That's always been the case. And in the old days, a nosy person would go to the courthouse, check it out, read all about it. Believe me, people did that. Now you don't have to. From your home, you can just get on the justice system and access all that information. And if you're a more private person that doesn't want people to know what your will says or where your property is going, maybe it's something you don't want to share with the world. Maybe one of your 3 kids owes you $60,000 and didn't pay you back, so you're going to equalize that when you die. That's a very common thing. But you don't want your neighbors to know that. Maybe you're disinheriting a child, because they became an Ohio State fan. You don't want the world to know that. So there's a lot of reasons that our clients want to keep things private.
Wow, that was just our first question.
Sorry, I won't talk as much.
No, I love it. I've got so much great information there. So what are some common misconceptions that people might have about wills, trusts, or probate? Can you clarify any misunderstandings to help all of us here make better informed decisions?
Well, one thing that I'll hear clients come in and say, well, if I create this revocable living trust, that will protect my assets from nursing home expenses. And so that is not true. So if you create a revocable living trust, those assets are available to you. They're still for your benefit, and it does not protect you from that. You would have to do some planning where you would have to actually get rid of those assets into what's called an irrevocable trust, so that you don't actually own them anymore. You've gifted them away. And you need to do that 5 years in advance of your passing as well to make that stick that way as well. So that's one common misperception. Andrew, you have some more, or Leslie?
One of the things that we see as a corporate fiduciary, a misconception is that our families are going to get along after we're gone. And I think that has to be an important part of the estate planning process. Investments can be easily divided, but what we find is that there are often disputes when it comes to tangible property, and we don't really consider that. A lot of us don't consider that when we're doing our estate planning, and I think you need to do that. Ultimately, the greatest legacy that we can leave is a family that gets along. And we don't always see that. We've got 3 children, and in our minds we think that after we pass, they're going to divide that tangible property up and it's going to go smoothly. But I think good planning is important so that it does. And that may be including a corporate fiduciary. It may be being diligent when it comes to creating what we call a laundry list, a tangible property list that says who's going to get what. when it comes to grandma's wedding ring or grandpa's watch or the buffet that's been in the family for a long time. I think we could all tell stories that some of the biggest arguments among family is in reference to the vase that's set on the Thanksgiving table every year.
Yeah, that's really true. If you could tell us how proper estate planning can contribute to a smoother transfer of our assets, and you kind of touched on it, Leslie, a little bit about the emotional aspects, but what about some of the financial and emotional benefits that you see for individuals for smoothly transferring that?
I think Andrew will go into more detail here, but I think what we find among our clients is they feel that once they've gotten their estate plan put together, that will and that trust that they're done and they're not, it's so important to look at titling of assets and beneficiary designations. And maybe I just led into the answer. I set you up, Andrew.
That was a good
so
softball, yeah.
You can go forward.
Well, it's a challenge after a parent dies or an uncle or an aunt to pay the bills. Every estate has bills. Even somebody who didn't owe anybody money when they passed away, they're going to have medical bills that Medicare and supplemental insurance do not pay for. They're going to have final income taxes. There's the funeral expense. Unfortunately, in Nebraska, we have an inheritance tax that's due within 12 months of the date of death. I got a former county commissioner here, so I got to be careful when I talk about the inheritance tax. But a typical estate, just an average estate, we're talking $30,000, $40,000 worth of bills. So where does that money come from? Well, if you're going through probate, you may have to wait some time because of the backup log in our court system to get appointed. Sometimes it could take weeks to a month to get access to the money, and that's very frustrating for families who want to take care of business. That's an advantage of a trust. When we're working with clients with a trust, we recommend that they put pay on death, POD, to their trust so that automatically the trustee of the trust can access the money to pay for expenses. Now, something that I know a lot of people do as a workaround on this is they put one child's name on the checking account as a joint owner. Now, we always advise against that. And that's the thing about advice, clients can take it or leave it. And a lot of our clients say, well, that's nice advice, now I'm going to put my daughter's name on the checking account because they're worried about paying for the funeral. Well, let me tell you, Tom Roper is my golf buddy at Hillcrest. He's doing just fine. He can wait to be paid for 30 days. He doesn't like when I say that, but I say it all the time, okay? And don't worry about getting the funeral home paid. That's going to be okay. They can wait 30 days. What's more of a concern is if you have 3 kids and you put one kid on the checking account and made her a joint owner, this is what you've done. After you die, she is going to own all of the money. Legally, she is under no compulsion to use that money to pay for your funeral or your expenses. She can just take the money herself. And even if your will says it's divided between your 3 kids, doesn't matter. If she owns the $60,000 that you have in your checking account, that's her money. She does not have to share it. Now, oftentimes I get that question from children. They're like, so I was the joint owner on the account. Do I have to use the money to pay for the funeral or to share with my brother and sister? And I say, well, there's 2 answers to that, daughter. Answer number 1 is the legal answer. No, you don't. It's your money. You can do whatever you want with it. Answer number 2 is the moral answer. Yes, you better do what your mom wanted and pay for the funeral and share it with your siblings, or she will come back and haunt you. That doesn't line up with my Protestant theology, but I do believe it. If you don't do what your mom wants, she will come back and haunt you. And that other thing that we see is, that's a mistake with this too, is putting a child as a joint owner of a home. Bad idea. So I know why people do it. They do it to avoid probate, and they put a child's name on the home. That's a mistake for several reasons. First of all, let's say mom puts her daughter on as a joint tenant of the house, and the daughter doesn't live there. When mom dies, the daughter's only going to get a half step up in basis for capital gains purposes. We have a lot of realtors here in the room, and they understand this. When you sell a piece of real estate that's not your personal residence, you have to pay 15% federal and 6% Nebraska, so 21% called capital gains income taxes on the difference between what you bought the house for, that's your basis, and what it sells for. And if it's not your residence, you have to pay that tax. If you receive it though through a will or a trust, the child gets what's called a step-up in basis and does not have to pay capital gains income taxes. But if you put your child's name on there, you're going to get a rude surprise in April of the next year, because you're going to owe about 21% on half of the proceeds from the sale of that house. Ouch, when you didn't need to do that. Another reason not to put a child's name on there, you may lose your homestead exemption. In Nebraska, if you are of a certain age and a certain income, you have reduced or sometimes eliminated property taxes. You put your child's name on there, you're going to find out you owe property taxes again. So there's a lot of reasons not to do it. And the final one is, when you put your kid's name on your car or your bank account or your house, you subject that property to your child's problems. They get sued, they can come after your house, your car, your bank account. They get divorced, your daughter's ex-husband, whether you knew it or not, owns a fourth of your house. Well, I didn't put his name on there. Doesn't matter. Spouses have rights in Nebraska. So you put her name on the house, then she gets divorced from her husband, depending on where they live. Your ex-son-in-law is going to get a fourth of the value of your home. So lots of reasons not to do that.
Yeah, and we do see that happen a lot. It's a big surprise to everybody when that happens. What are some legal aspects that individuals should be aware of when they're creating a will, or maybe, Doug, you could tell us, in a trust?
Well, legally, you would. Okay. Well,
Okay.
They're making the lawyer answer the legal question. Well, I know that it's becoming popular to do it yourself, DIY. We see it all the time because we probate a lot of DIY wills. And I'll be frank, some of them work. There's some really good programs out there. You might be surprised to hear me say that, but you bet. There's a lot of programs out there that do work. But I think the benefit of an attorney-drafted estate plan may not necessarily be the document itself, although it wouldn't surprise you to know that I think our documents are better. But it's the counseling that we provide about the things that we're talking about today, about what to do and what not to do and how to fund the documents. But at a base level, the requirement for a will is pretty simple. The signature, this is pretty old-fashioned, but the signature and the date have to be in your handwriting. They cannot be typed. So this is where DIY wills get in trouble sometimes in Nebraska. And by the way, I'm only licensed to practice in the state of Nebraska. I have law partners who are licensed in Iowa and Kansas. We're a 3-state law firm. We're very careful not to work with people who don't live in one of those 3 states. Other professions like accountants and financial advisors have more flexibility and can work with your kids who live in Arizona. We can't. So wish we could, but we can't. So I only know the Nebraska, and there's a good reason for it. The laws are very different in every state. So in Nebraska, that's a requirement. The signature in your handwriting, old-fashioned wet signature, and the date. We had a case out of Grand Island about 10 years ago where somebody typed a will on the computer, typed their name, typed the date, pressed print. That's it. Supreme Court said, no go. How do we know? Pretty old-fashioned, but doesn't matter what I think. They're the Supreme Court. That's not a valid will because the person didn't sign it and they didn't date it in their handwriting. Now, that's really the only requirement to get it admitted. Now, the reason that in law offices we have witnesses and notary publics is not that that's required per se. You could still have a valid will if you signed and dated it. But if you have that formal signing ceremony where there's 2 witnesses and a notary watching you, we can admit that will informally, which means we don't have to literally go to court. If I just have a will that was signed and dated by somebody, I gotta go see Judge Parsley. And right now, if I called right now to get a hearing, it's gonna be 2 to 3 months out because she's so booked. So that's really frustrating when they want to sell their house, right? And again, back to the realtors in the room, in order to have somebody sign a listing agreement with you, or a purchase agreement with a buyer, or a deed when it sells, they have to be court appointed if there's an estate. And if it's a formal proceeding because someone had a DIY will, it's probably 3 months before we can even sign a listing agreement. So that's very frustrating for people. But the legal requirements are really just the signature. Oh, and you have to be 18.
Yeah, I might add some things that Leslie and I see as well sometimes. I mean, there's nuances in words that you use in estate plans. So do you mean to use the word shall or may? You know, that means two different things. And Leslie and I are all about following your instructions. And so, and Andrew's all about legally representing you to make sure you get your intent in that document. Now, when you're doing things like that yourself in programs, you're not going to necessarily understand all those nuances, and really that conversation with your legal representative is going to flush all that out so that they make sure that that they get your intent in that document. So that might be something I point.
And I'll just follow that up with, it's not uncommon for us to be visiting with clients and they'll say, well, I'm just gonna do this myself. We will always recommend that they go to an attorney that focuses in the estate planning and trust administration area. It is a wise investment. It doesn't cost that much to get a good estate plan in place. And it's better to spend the money so that you know you have a good plan in place.
And I might add too, from a corporate fiduciary standpoint, we really count on those attorneys sometimes because at the back end, if there's trouble, you know, we want that person who represented you to step up and back those documents, because the last thing is you did the estate plan to help prevent any problems on the back end. So if there's any clarification that needs to be done or anything like that, we really depend upon those legal representatives who represented you to make sure that it happens the way you wanted it to happen.
Great. Well, and you kind of answered my next question, which is how can a legal representative help guide you through the complexities of a will and a trust? But Andrew, you talked about being able to do a will on your own. Can someone create their own trust without a trust?
Oh, sure. You know, these programs, again, and we know that it's a wave of the future for lots of things, is artificial intelligence. We've played around with it. We don't use it in our office, but you know, ChatGPT can write a pretty darn good will, believe it or not. And it's a whole new world. If you haven't played around with artificial intelligence, it'll scare you how amazing it is. But what artificial intelligence cannot do is make sure, it can write you a trust, but it may not tell you that you have to make sure that your house is owned in the trust. The number one reason that there's probates when someone has a trust, you know, just by signing the trust does not mean you avoid probate. So if you have a trust because a lawyer did it for you 30 years ago, but your home is just in your own name, guess what? If it's worth $50,000 or more, and I know it is, there's gonna be a probate. And so you have to go, it's not rocket science, but the devil's in the details. You gotta go back and make sure that your house is owned by the trust, your personal property is owned by the trust. It's what lawyers and trust officers call funding the trust. So that's a takeaway for all of you here today. If you already have a trust, go back to your lawyer, back to your accountant, back to the financial advisor and say, will I avoid probate when I die? And they'll know or should know the answer. And it might be as simple as a deed or an assignment, or if you own an LLC, putting a transfer on death designation on the units of the LLC. But in the absence of that, again, back to our joke, you won't be worried about it, but your family's not going to be happy with you. Last week I had the classic situation. I had done a trust for them several years ago. Then after we did the trust, the husband inherited a farm, and he didn't get around to doing a transfer on death deed or getting his wife's name onto it, and he died. So it doesn't matter that they signed the trust. She's mad at him, by the way. She's like, thank God. Because she has to hire me to go to court just to get that farm into her name, whereas if they had just done a deed, very simple, inexpensive document, there wouldn't need to be a probate. So that's just an example of something that happens, and why you should, if you have a trust especially, follow up and make sure that everything's done. If you just have a will, as I said before, if that's your comfort level, you probably don't need to worry about those things, because everything goes through the court system after you die, which I already talked about why that's maybe not the best thing. But with a trust, to answer your question, if you've done a do-it-yourself trust, you might be missing those key things like making sure your house is owned in it.
Yeah, it's a lot to put out there by chance, isn't it? You kind of answered our next question about when is it more suitable to have a will versus a trust. Are there any other reasons besides that $50,000 mark why you should have a trust?
Absolutely. So trusts, I mentioned, are for lots of different reasons. One is to delay an inheritance. Are you leaving money to a child who you do not think is economically mature yet? That's a moving target for different kids. And maybe it's not a great idea to leave your 21-year-old child or grandchild $1 million, because they'd have a lot of fun, but it wouldn't be there by the time they're 25. So a lot of people use trust to delay the age of inheritance to 25, 30, 35, even 40, to protect a child from a divorce, to protect them from a lawsuit, to protect them from just being a spendthrift. That's something we're seeing a lot, is kids and grandkids who just cannot handle money. They just spend it like crazy. If your child has an alcohol or drug problem, the last thing you should do is give them a bunch of money, because they will kill themselves. So you want to hold it back in trust for their benefit. Maybe only if they're sober they get distributions, or they have to prove that they're being responsible. If you have a child or grandchild or niece or nephew with special needs, maybe they were born with a disability, or maybe they had a workplace injury and they can no longer work and are dependent upon the government for money, please do not leave them a bunch of money. You will have simply disqualified them from receiving the government benefits that they would otherwise be entitled to. The better way is through what's called a special needs trust, which is a trust that holds the money back for their benefit. We always highly recommend, if you're doing that, to name a corporate trust department like UBT, because they know the rules, and these are easily screwed up just because they're so complicated, and those rules constantly change for disabled and special needs individuals. And so you want to work with a professional if you're going to do that, for sure. And Doug mentioned another type. There's, again, 100 others, but an irrevocable trust, which if we're worried about the nursing home, and there's a good reason too, because of how expensive long-term care is at this point, on average for long-term care, 8, 10, 12,000 a month. That's a way to, something to think about.
Yeah.
I might add one other thing as we talk about different trusts too, like irrevocable trusts. So the other thing that we're always constantly aware of is taxation. So, when you die, the federal government gives you an exemption on value of assets. So starting January 1, every single person in this room has a $13.6 million federal estate tax exemption. So if you're over that, then they could be charging you at 40% of anything over that 13.6 million. And so there are some really sophisticated estate planning techniques so that you can minimize those taxes to the federal government if you fall over that amount. So you may think, okay, well, that doesn't affect me, and it doesn't affect many of our clients, but that law is set to sunset on December 31st of 2025, and it's going to go back down to 5 million, and it's going to be adjusted for inflation, so maybe the actual amount's going to be 6.5 or something like that. So that starts to affect a lot more people, and especially ag owners, and maybe there are some things that you need to be thinking about before that date hits. So that's one other thing, that different types of trusts can help minimize taxes, but essentially it's going to be an irrevocable trust that you need to get assets out of your estate, so you'll fall below that amount. Or there's other types of trusts where you can make annual gifts to and buy insurance policies to help cover paying those taxes as well. So there's different strategies and techniques.
And you want to tell them the new amount for next year, 18,000.
Oh, and so also starting January 1 of next year, you also get an annual gift exemption amount, which next year goes to $18,000. So every one of you can give $18,000 to as many individuals as you want, and you don't have to file a gift tax return.
And I'll add another situation that we see quite frequently, and that's when the trust, I like to say, is kind of a safety net for you. If one spouse would pass away and the surviving spouse is in their 90s and maybe starting to struggle a little bit, that successor trustee is able to step in, and there's not a need for a guardian or a conservator. The successor trustee can step in and pay bills. They can make sure that tax returns are filed. If mom is suffering from dementia or just having some difficulties making sure that everything is getting done, that trust is in place for her or him or dad as well. So whether it's a child or a corporate fiduciary, they've got the ability to step in and take care.
Good. Some really great points. Appreciate you guys sharing all this. We're going to take a short break, and before we do, before we have our break, we always have a educational partner spotlight, and today we're going to spotlight Nina Chase, and she's with Stay Home Care, and she's an amazing woman. She's got spunk and vitality, and she has a real passion for caring for people. So go ahead and grab a mic here, Nina, and tell us why you do what you do.
Hi everyone.
Hold that up.
A little more. Okay. My name is Nina, and I used to be a caregiver for my grandmother. She got diagnosed with dementia, and I was a stay-at-home mom, and she tried to burn her house down by making tea and left the gas on. So then I decided that I'll take her in and take care of her, because of the language barrier, she couldn't go to a nursing home or facility. So she came and lived with me, and then through that I hired an agency to help me take care of my grandma for when we would travel with family or when we go to places, and I had a 2-year-old. So then after a while I ended up, when she passed away, I applied to be a manager at the in-home health care that was helping her at the time. So throughout my experience I realized I want to make a difference, but even being a manager at the company, I wasn't able to make the impact. So I started my own, and with that, I was able to do what I really wanted to do. Not just help the individual that needs the help, but also the people that are providing the care. And that was the most important, to be the support, because in-home health, we're coming to your home to take care of you, and we specialize the care for you individually, so you're getting that one-on-one, and the things that you need done are being done. But the caregiver doesn't see the management as often or has the support. So I believe in taking care of the caregiver and being the backup and being the support, and in return she will provide her best to the person that needs the care. And so I call it a circle of trust. I trust you, they trust them, and then you trust me. So it's all in one. So we've been in business for about 1.5 years, and we're still going good. Yeah.
And her business is growing by leaps and bounds, so that's a testimony to the care that she does provide.
Yes.
So thanks for coming up. We're going to take a quick break. Restrooms are right back there. The women's is there. I think the men's is around the corner. Is it? Or where's the men's restroom? Is it over there? Anyway, grab yourself something to eat in about 5 minutes and we'll come back. Okay, everybody, we ready to get rolling again? Everybody all energized and revived? So now we're going to explore some different nuances here about probate challenges and solutions. What kind of challenges can arise during the probate process, and how can some of these be mitigated?
Well,
I think the biggest problem in probate is having the wrong executor named. That's our biggest challenge after mom and dad die, is if the child is a procrastinator. I had a real bad one a couple years ago, large farm estate in central Nebraska. And I read the obituaries in the Journal Star every day, but I don't read the Clay County News. And the son calls and he's like, well, I guess I should tell you that mom died. I said, well, I'm very sorry for your loss. When did she die? 3 years ago. Oh boy. So all the deadlines were blown, because the deadlines are 9 months, 12 months. And so that was a mess. So if you're naming somebody who isn't able to balance his own checking account, wrong person to name. Other big problems are siblings who don't get along. And Leslie said it earlier, and we always chuckle because everyone tells us their kids are going to get along, and we don't believe you.
Yeah.
Because after parents die, childhood jealousies bubble to the top. She got to go to college, I didn't. You were always mom's favorite. And then the outlaws cause problems. So sometimes it's not your son or daughter, it's their spouse who causes the issues. And so that's the biggest problem in an estate. And if you have your two kids named together and they disagree, and people will say, well, what could they possibly disagree about? Give you a classic example. One kid thinks we should sell the house on our own, and the other kid thinks we should use a realtor. And if they disagree on that, it's a tie. They got to go see Judge Parsley. So the most important decision you're going to make, there's no close second, is who your executor is going to be. We call it a personal representative in Nebraska. Or if you use a trust, who's your trustee? If you have those family dynamics, or your kids are just too busy or don't live nearby, the best thing you can do is name an independent third party like UBT. That's what trust companies do, is they step in and fill that role. One of the best things, I'll do a little sales pitch for these guys, because I'm a true believer in corporate trust departments. One of the coolest things about a trust department like UBT is they do not charge you anything until you die. So you can name UBT as your executor or your trustee, and they're not going to, until they have something to do, there's no charge. Another thing is they offer to hold the original documents for free, which is awesome. And then I know that why most people are hesitant to name a trust company is they think it's too expensive. In most situations, it's actually probably going to be cheaper, and here's why. Your child or niece or nephew who's named as the executor, they're entitled to a fee. And oftentimes that causes problems. My mentor was Doug Deitchle. I worked with Doug for 20 years before he retired, and he was fond of saying, no matter what you take as your fee, your brother and sister are going to think it's too much because you're taking away from their inheritance. So you've got that family dynamic. And then if your child is an attorney, that's one thing, but if your child's not a lawyer or an accountant, he or she's going to have to hire a lawyer like me, hire an accountant, hire a financial advisor. That's fees, fees, fees. So when you put that on top of the fees that the child's going to pay, UBT has in-house lawyers, in-house accountants, in-house financial people, so they can do all of it, and it's usually less expensive.
Oh, what great point. Great point. What are some strategies that might help streamline or expedite the probate proceedings? Or is there anything that we can do to bump that up? I know you said the judges are booked. Is that the only thing that holds up probate?
Leslie and I often talk about the roadmap of estate planning, and just part of it is knowing, whoever is going to be your personal representative or your successor trustee, where are those assets? Are they in 20 different places? Because man, that's going to take some detective work to figure all that out. And so, you know, on the front end, as you're doing your planning, it's always nice to have that asset summary sheet, you know, and who knows, maybe you tell your kids, hey, if something happens to us, it's, you know, all my list of assets are in the left-hand bottom drawer of my desk or something like that. And so that's going to be a really helpful thing, because otherwise they're going to have to rely on maybe looking at your emails to find out where everything's at, waiting for mail to come, and that can really slow up the whole process as well. So Leslie and I talk about that all the time. And then usually, you know, later in life, you want to simplify things rather than to make them more complicated. And so a lot of times consolidation of assets can also help. So instead of 20 financial institutions you're working with, maybe you can narrow that down to 3 or 4 just by doing some consolidation, because life happens, and you know, you go and open up new accounts for different reasons, but at some point it's kind of nice to bring it all together as well.
Great. Okay, so as far as the role of trust professionals, how can a trust professional assist in the administration and management of that trust? What do you do?
So I like to say when we step in, we become detectives. And so many times we don't know what we don't know. So I think it's very important for you to have your team of professionals collaborating together. So what we like to do, as Andrew and Doug had mentioned, we don't charge. Just because you name us within your plan, we don't charge until we actually step in. That may be a 30-year runway, but it is so important for us to be collaborating with you, with your estate planning attorney, your accountant. And the more information that we can have in our files, the better off we are. And we can help guide you down that runway. So we want you to come in on a regular basis. We want to find out what those assets are. We want to have that roadmap in our file. And I know some of our clients are here today, and I commend you for being here, because having that information in our file is so important. Life happens, things change, and we're gonna talk about this in a minute. But we want to know about those things that have changed within your life, whether that is a marriage, it's grandchildren. I've divested myself from my business. I've started a business. All of those things are important for us to know, because we can help you. It's not uncommon for Doug and I to be sitting with clients and talking about titling and beneficiary designations. Every financial institution has a different way that they want you to update beneficiaries. And we can help guide you through that process. We can also stop you and say, hey, you need to get back to your estate planning attorney. This is a significant situation, and you need to update that estate plan. Now, when we step in, this is what we do every day. When we're named as trustee and we're named as personal representative, this is our full-time job. And you may have a very capable child that you have named, but they're living in Connecticut. They have a full-time job. They have 5 children of their own, and it's hard for them to get back to Nebraska. Or you know, they have a wonderful job, a very important job, but it's not in the financial sector, and this is all very foreign to them. So we bring that many years of experience and expertise to the table.
Well, I'm just thinking, who wouldn't want you guys in your corner? You know, to figure out all this stuff and keep track of all this stuff. I would think that would be a big assurance and peace of mind to your client.
And I'm going to add one other thing. I have 3 children of my own. The best legacy that I can leave is 3 responsible adults. If I put my daughter in charge of my plan, and my son has to go to my daughter and say, hey, when am I going to get that distribution? That might not go well. I would much rather have my son come to a corporate fiduciary and ask that question. If he wants to be mad, have him be mad at the corporate fiduciary, because he's not going to leave this world with my assets. but he is gonna have that sister for the rest of his life.
Yeah, and I can see where you're building this relationship and it's an ongoing thing. It's just not a one and done, but you're helping them all that way. That's wonderful. We're gonna talk about managing and maintaining those estate plans once you get those in place. So why is it crucial for individuals to regularly update their trust and their wills?
Well, so life happens, and in our world, Leslie and I always say you need to pull out that estate plan and just review it about every 3 to 5 years, and you just determine, whether it's still relevant to your situation in life and your family as well, and how you want things to go. Leslie and I will review estate plans with people all the time. And we just walk through it and say, here's the story you're telling in this estate plan. Does that still sound right? And, a lot of times yep, that's still right. But then every once in a while you'll come up with something where that's not relevant anymore. It's like, okay, you need to get back to your estate planning attorney to get that updated.
I had a wise attorney say to me just recently, it's the 5 Ds that you want to be considering on a regular basis. That's death, disability, divorce, descendants, and decade. And decade may be a little bit too long to wait to review your estate plan. But what I like to say is it's tax time again already. Many times we put together or we update that personal financial statement as of December 31st. I say, look at your estate plan. You're looking at your assets. Also consider how send out a reminder to our clients at least every 3 to 5 years to say, hey, pull that plan out, take a look at it, and let us and your estate planning attorney know how we can help.
Yeah, that's really important. I'm just thinking back to my trust. We developed one for our kids, and it talked about how we're going to pay for their college. Well, they're all, 40 years old and have kids of their own. So I'm thinking I need to get mine updated, right? I don't know if anybody else procrastinates like me. So you talked about some of those events that can prompt us to want to make some of those changes to our wills or our trust. Are there any ones that would prompt us to, hey, you need to do this right now, that are more of importance?
Yeah, for sure. So if your spouse dies, that's the number one thing, because there is a deadline for a filing that there are not taxes due, but there's benefits to you and that is a strict 9-month deadline. So if your spouse dies, you're going to need new powers of attorney. Most estate plans contemplate, I had a wonderful member of your audience come up and ask me about premature deaths. It's horrible when a child dies first. That's not what's supposed to happen. But most estate plans talk about that. So even if a child has died before you, hopefully if it's a well-drafted plan, that doesn't mean you have to change something. You might want to, but definitely when the first spouse dies, you need to take a look at things. And then another one, and Leslie mentioned it, and I know that lawyer, and I'll tell her that you quoted her, because she'll be very flattered that you did. Divorce. We see a lot of people who spend a lot of money on their divorce lawyer and then don't get around to changing their estate plan, and their ex-spouse is in it. So, for goodness sakes, that's a biggie. There's lots of them, but those are the two biggies.
I'm gonna add to, and I'm gonna give Kay a little bit of kudos here. The worst time to be updating your estate plan is in crisis. We have so many clients who will have a medical emergency and things just, the cart is upset immediately, and Andrew can tell stories as well. That's the worst time. Plan long before there are medical issues that could come up, or housing issues, and if you or your family are looking and needing care, you need to contact Kay with Bridges to a Better Living, because they help facilitate that change in crisis and long before crisis, call them long before that, but that's the worst time to be trying to update your plan.
Yes, I can understand that. Would be the last thing you probably want to put your efforts and concentration in at that time. So now we're just gonna, the last part is just talk a little bit about some inheritance and tax implications. And if you could discuss some of those that are associated with inheritance and how we might minimize some of those tax burdens.
So when somebody dies, there are 3 types of taxes that potentially impact the beneficiaries. And I'll talk about all 3. It's complicated because there's different types of taxes and different assets are taxed differently. So let's talk about them. The first, Doug already mentioned, it bears repeating, is the federal estate tax. You'll hear a lot about that tax in the presidential election because of the law change that Doug mentioned. But the truth is that the vast majority of our clients don't have to worry about it. Because as Doug mentioned, if you're worth less right now than 13.6 million, that always makes people laugh, you don't have to worry about it. The problem for Nebraska farmers and ranchers and business owners is that sunset when it goes down to 5 million, because the difference between 5 and 13 is the average Nebraska farm. But for most people, it's not something they have to worry about, because with proper planning, if for a married couple, you can double that exemption. So if it goes down to 5, you're actually in the clear up to 10. But there's 2 other types of taxes that impact everybody. So let's spend our time on those. The second tax is the Nebraska inheritance tax. Now, I was teasing my friend Larry Hudkins earlier. And the reason is he's a former county commissioner. And this is a county tax. Now, you may not know that, but Nebraska is unique in a lot of ways. We do everything different than everybody else. We got the one-house legislature that Carol served and Larry served in. We've got things different. Well, one thing that's different is we're the only state in the country that collects our inheritance tax at the county level. That revenue does not go to our state. It goes to the 93 counties. Last year, that inheritance tax brought in $77 million for the counties. It's projected, Senator Clements told me, I saw him last week, Chairman of the Appropriations Committee from Elmwood, told me it's projected to be $86 million this year. And so we're talking big dollars. We're also unique in how we tax people. So here's how it goes. Nobody else does it this way. We tax people based on how they're related to the person who died. So if you are a spouse, you pay 0 taxes. So a spouse, when she receives property from her husband who dies first, no Nebraska inheritance tax. That's good. Qualified charitable organizations do not pay tax. You pass away and leave your estate to your favorite qualified charity or church, they do not pay inheritance taxes. Then there's 3 categories of people that do. The first category are close relatives. We define these as children, grandchildren, brothers and sisters, parents, and anyone married to one of those people. Each one of those individuals gets the first $100,000 tax-free. That used to be 40, but it went up this year to 100,000 per person. That's good. So if you have 3 kids, when the second spouse dies, and you have an estate of $500,000, the first $300,000 is a 0 tax, and then 1% of everything over that, so 1% of $200,000, which is $2,000, goes to the county. So most estates go to children, and the truth is that this is not, 1% of a York County farm is a big number, but for most estates, 1% is manageable. It's just more of a nuisance. So most of those checks that go to the county are pretty small. Where the Nebraska inheritance tax becomes regressive, in my opinion, is for remote relatives and non-relatives. So hold on, because this gets to be kind of nasty. So if you pass away and you leave your estate to a niece or a nephew, and we have a lot of clients who don't have children, and most of them tend to leave their estate to their niece or nephews. The niece or nephew receives the first $50,000 tax-free. That used to be $15,000, but we bumped that, and that's a good thing, to $50,000. But then after that, they pay 11% to the county. 2 years ago, I had a wonderful client come in, and she was just flabbergasted. Lives here in Lancaster County, that's all I'll say, because you can't talk about who your clients are. And she had an uncle who had just left everything to her, and she didn't realize he was a very wealthy man. And she got a huge check, but then I had to deliver the bad news. It was then 13%, that we had to send 13% of that to the county. And it was hard for her to do, but she wrote a check for $760,000 to Lancaster County. Wow, and the only reason is that was her uncle, not her dad. I feel like that punishes people who don't have children. And so what I would like to see is those rates to come down, and they have been, in all fairness, they've been coming down. Now it gets worse. If you leave your money to a non-relative, and we do not have common law marriage in Nebraska. Iowa does. If you live with somebody in Iowa as spouses for 7 years, then you're spouses. Not true in Nebraska. You could live with your girlfriend for 30 years, she's still not your wife. And so if you leave a non-relative money, and most people don't know this, it's a real zinger. They only get the first $25,000 tax-free, and then, ouch, 13%. Used to be 18. 13% of every dollar over and above that goes to the county. Now, there's a few things that are not taxed by the Nebraska inheritance tax, really only two. They are life insurance to a named beneficiary. Why? I think it's because the life insurance agents have the best lobbyists. I don't have another reason for that. Would you agree with that, Larry? I think that's right. So life insurance is exempt. No inheritance tax, no income tax. It's a great asset at death. The other asset that is not taxed by the Nebraska inheritance tax is real property in another state. So you have a house down in Arizona, that is not taxed by the Nebraska inheritance tax, but everything else is. And by the way, the reverse is true for a non-Nebraskan. My daughter lives in Houston, Texas, and she loves it there because it doesn't snow. And I don't think she's coming back. I wish she would, but I don't think she's coming back, Kay. So she lives in Texas. So if she inherited property from her mom and dad, it doesn't matter that she lives there. She's still going to owe the tax. And if she owns real estate in Nebraska, and she'll stand to inherit part of a Nebraska farm. My wife grew up on a family farm near Hooper, Nebraska, hometown of Jordan Larson. And that farm's been in their family since 1903, and they're not going to sell it. That's not going to happen, at least at my wife's generation level. But then if my daughter ends up inheriting part of that, even though she lives in Texas, she would be taxed at her death on the real estate that she owns in Nebraska. So that's kind of a reverse one that a lot of people don't know, that a non-Nebraskan is taxed on their real estate in Nebraska. And when do they find out that bad news? When the title report comes back for the closing that says, oh, you owe an inheritance tax. By the way, the person died 5 years ago, and it was due 4 years ago. It's due within 12 months of the day of death, and you didn't know it, but 13% interest and penalties have been accruing for 4 years. Because that is a lien. The real estate professionals in the room know this. Most people don't. It is a lien on the real estate. So when you go to sell the real estate, you gotta pay the tax, or there's no title insurance. Yes, ma'am.
Where do stepkids fit in?
Great question. The question is, where do stepchildren come in? And it used to be that they were non-relatives, but we went in and changed the law recently, so now stepchildren receive the same treatment as a child, which is a big darn deal. Now, to piggyback on your question, there's another category out there, and that is somebody who you've considered to be your child for at least 10 years. That happens. I've got clients who had foster kids who are not their legal children. They didn't adopt them, but for all intents and purposes, they considered that person to be their child. Technically, they should be taxed at the 13% rate, But if we can prove to the county attorney, and that's actually who's responsible for collecting the tax is the county attorney, and you pay it to the county treasurer. And so the county attorney's job is to collect as much tax as possible. If I can show the county attorney that for 10 years, we considered this person a child, I reduced the tax from 13 to 1, which is a lot. I've had this come up twice in 25 years where the county attorney said, no, I don't agree. And both times, even though I'm not a litigator, I don't go to court. I did for these two. It was in Dodge County and Fremont, in Gage County and Beatrice. And I came armed with cards that were to mom from like 15 years ago. They called her mom. And then both of these situations, I had it teed up because I knew that this was going to be a problem. They were both clients of mine before they died. I said, we're going to write your obituary before you die. And you're going to say, this person who I considered to be my child for 20 years, that's right out of the statute. So that was Exhibit A, and we won both of those. But you have to prove that you've considered this person a child. So that's the interesting, some people say strange, Nebraska inheritance tax that if you didn't know about it, it's been around since 1901, so this is nothing new, and unlikely to go away because the counties are resisting that. The final tax that impacts everybody is income taxes. Now this is a more nuanced discussion. I am not a CPA, but I play one on TV as it relates to death. So when somebody dies, there are certain assets that you aren't taxed on, and there's certain assets that you're taxed on in a big way. Well, first of all, when somebody dies, they'll have a final income tax return that's due, a final 1040 for that year, and what's called a 1041, which is a fiduciary return that has to be filed. Any accountants in the room? Okay. All right, now I can say whatever I want. No, I'm kidding. So we do not do income tax work. We always work with a CPA on this because we don't want to mess it up, because everybody has these issues. But there are certain assets that the children do not pay, if done correctly, do not pay income taxes on. Those include real estate, I mentioned it earlier, but if done correctly, we get a step up in basis. So you sell mom and dad's home, if the lawyer does his or her job correctly, we value it at exactly the sales price and we eliminate the capital gains. I see some lawyers do that incorrectly. Cash, there's no income tax on a cash gift from your parents or an estate. Personal property, there's no income tax on the vehicle or the tractor that you get. Life insurance, I already mentioned, is not taxed by income taxes. Okay, what is taxed by income taxes? That is qualified tax-deferred accounts, things like a traditional IRA. And for most folks in town, that's your largest asset. That's your 401k at work that you've contributed to every year that your employer has probably also matched to a certain degree. And you may not know it, but that you have not paid taxes on that. It was funded with pre-tax dollars, which is great for you because when you're retired, you'll have to start taking required minimum distributions, RMDs, at age 74. They just changed that age again, right? 73, thanks Doug. Thanks for the assist, 73. It used to be 70 and a half, then it was 72, now it's 73. So you do have to pay income taxes on that withdrawal, it's required, but the public policy behind this is that it sustains you during your retirement. There's only one person that you can leave your retirement account to who doesn't pay taxes. Who's that? That's right, a spouse, that's it, only person. You could also leave it to your favorite charity and they don't pay taxes, and that's what a lot of charities are encouraging, is people to leave their taxable assets to the charity to eliminate the tax. But when that IRA goes to your kids, they're going to pay big time in income taxes, and they don't know that, and sometimes you didn't know that, and I'm often the bearer of bad news. So they come in and like, oh wow, can you believe Dad's IRA rolled over to Mom, and then she had a great investment guy and he got it up to 1.2 million. Can you believe that? And I start to cringe. I'm like, yeah. And it's going to the 3 kids. Yeah. And then I have to tell them that there's a tax event, and it's not capital gains rates, which are lower. It's at ordinary income tax rates. So your daughter, who's a doctor, who pays at the highest possible income tax rate in the 30%, she's gonna lose 30, what's the highest, 37? 37% of her 400,000. That's a big number. And there's nothing I can do about it. There's only one thing she can do, and that is pay it over 10 years through what's called a decedent IRA. But that's how taxes are paid on those qualified accounts, and that's a big ouch. And if you didn't know that, don't feel badly, because most people don't. That's how these things work. They used to work better before the Secure Act of 2020 screwed it all up, but that's water under the bridge, and Congress is not going back on that. So the bottom line here is traditional IRAs, 401ks, annuities, your children will pay big time income taxes on. The only way around it is to leave it to your church. So leave it to Christ Lincoln, that's where Kay and I go. Leave it to your church, and there won't be any taxes.
Can you move it to a different account?
The question is, can you move it to a different account during your lifetime? And the answer is yes, but you have to pay taxes on it, because the money comes out and you have to pay taxes. So a common thing is a conversion to a Roth IRA, because with Roth IRAs, they're tax exempt, but you have to pay the piper at some point. And so oftentimes parents will convert it and they'll pay the tax because they have a lower income tax rate than maybe their successful children. But the parent will have to pay the taxes when it comes out. So there's no tax-free way to transfer that tax deferred. That's the essence of the account. You haven't paid taxes on it. Taxes will be paid at some point.
So if I moved it to my, I forgot what the account's, like it's a savings account, but it's a different account. From my Edward Jones account and moved it into that, I would have to pay what percentage? Like maybe kind of a range?
So the question is, I have an IRA that was mine through work, and now I have it at Edward Jones, and I want to take that money out of the IRA and put it into the savings account, because you told me that kids don't pay income taxes on savings account. What about that? That's a taxable event for you. So whatever your income tax rate is, that's what you'll pay income taxes on. And there's no getting around it. It'll be due in April of next year. So if your income tax rate is 20% and you take out $1 million, you owe $200,000 to the federal government in April of next year. And oh, by the way, under current law, you owe 6% to the state of Nebraska, but thanks to Governor Pillen, that's coming down to 3.9% next year.
In April? When?
In April of, excuse me?
It goes down to.
Oh, when does it, it's not next year, is it? It's okay.
Oh.
Larry knows. So it's gonna go down over 4 or 5 years eventually to 3.9%, which is great. We haven't had a reduction in our state income tax for a long time. It's a big deal.
Great.
It's lower than Arizona.
I got a question. So, once you turn 72, you have to take out, what is it, 3% of your IRAs or 401s or whatever, isn't it? Or did they raise it again to the age of 73? I don't know.
73 is now the age for RMDs. So, and then there's a chart that you can look up to see what that percentage is that you're required to take out. And that.
But isn't 3%, isn't it supposed to be 3% or something? That's what I was understood.
Well, it goes up every year.
Oh, it does?
So that's why you gotta look at the chart and what age you're at. So, yeah.
Okay, so we have time for a couple of questions. Does anybody have a question for us? And Dave's gonna come here with a microphone and go out into the attendees here, and so everybody can hear the
The
question.
best part is you don't get a bill. Free lawyers. So, all right.
Yeah.
All right.
Who's got a question? Raise your hand. We have time for a couple of them.
If you have already done the trust and whatever,
That way everybody can hear the question you're asking.
if you have a trust already and you signed your car and everything to your daughter, I have a child, Is there any way then that they can be made responsible for anything that comes up, like medical expenses or anything else on you?
So the question is, the trust says that your property goes to your daughter. Because of that, would she be responsible for your medical bills? And the answer is no. Your child is never responsible for your medical bills. However, your assets are. So in essence, yes, so the legal technical answer is no, but if you have $200,000 worth of medical bills when you die and $400,000 worth of assets, before she transfers the property to herself, she has to use $200,000 worth of your assets to pay for your bills. Now, we handle bankrupt estates because of how expensive healthcare is. And so there are plenty of estates that have $400,000 in medical bills and only $200,000 in assets. We're not going to lose all of the money, but most of it. So it's just like a bankruptcy. There's a schedule that says who gets paid. Tom Roper must have good lobbyists, because the first thing is the funeral home. They always get paid. Then lawyers always get paid. We have good lobbyists. And the personal representative gets paid. And then most families can keep a very small amount, about $12,800. And then it's a list of creditors. Secured creditors get paid first. Unsecured creditors usually get, dimes on the dollar. But it's just like, and it happens because of medical debt. I mean, it's unbelievable how much people maybe without insurance would have in medical debt. So your child is never responsible for your bills, but your assets are.
Okay.
And I will add one thing. There's a big exception to that, what I just said, and that's a spouse. So I was talking about kids because your question was a child. Spouses are absolutely responsible for the debts of their spouse, and a lot of people don't know that.
Okay, we got another question?
So as a single homeowner, is there a way to set up my deed so it doesn't have to go through probate?
Yes. So since 2008, we have had what's called a transfer on death deed, TOD deed. So to answer your question, can you do a transfer on death deed? The answer is yes. Do I think you should do a transfer on death deed? The answer is no, and I have several reasons for that. Let's say you have 2 children, and you put transfer on death to your 2 kids, but one of the 2 kids dies before you. Now, it's just going to transfer to one child, whereas in a will or a trust, you probably would have said, those 2 children are my beneficiaries, but God forbid if one of them dies, their share goes down to their kids, my grandkids. So if you put TOD to your 2 kids on the house and one dies before you, unlikely but possible, you may have unintentionally disinherited your grandchildren. The other reason we strongly recommend against it is because of a recent case out of Minnesota. It's the State Farm case that every lawyer knows about because they've made us nervous, because I used to do TOD deeds for residences, but I won't anymore, and here's why. In law school, it's kind of fun. I'm a nerd, I love law school. You read all these cases about things that happened that led to lawsuits. There's always a fun story. So this is a story I'll tell quickly. And they're all true stories, so it's fun. So there was a couple in Minnesota who was getting divorced. And they got tired of paying their divorce lawyers, because divorce lawyers know how to charge. And we're cheap in what we do. And they went to each other like, well, I'm tired of paying these lawyers, aren't you? Yeah, let's just do it ourselves. And this was the soon-to-be ex-wife's idea. She's like, just do one of those TOD deeds, and on the deed say it goes to me when you die, and that'll kind of equalize things, because I think you're going to probably die first. Okay, sounds good. So that's what they did, and she was right, he did die first. The only problem was he lied to her. People lie. And he did not put her name on the TOD deed. He left it to his girlfriend, who caused the divorce. So the ex-wife did what any scorned ex-wife would do in that situation. She burned the house to the ground.
Oh.
To the ground. She got in trouble. But here's the problem. When she did that, the homeowner's insurance, State Farm Insurance, said, oh, there was a TOD deed. And you know what? This is insurance people speak. The ownership of that house transferred immediately on that gentleman's death to the girlfriend. And that fire didn't happen for a couple weeks. And you know, she did not have any insurable interest in the home, so we're gonna pay zero for the completely totaled house. Well, she didn't like that, so she sued. Well, State Farm won. They've got good lawyers. And then she appealed. Guess what? This is why we're having the conversation here in Nebraska. She appealed to the 8th Circuit U.S. Court of Appeals in St. Louis, and State Farm won. Supreme Court wasn't interested. Now that's the law for every state in the 8th Circuit, which includes Nebraska. So every lawyer is really gun shy about TODDs with residences. The only workaround is, and you gotta do it, if you're gonna use a TOD deed, is to go to your insurance provider and add your children as additional insure-eds on the policy. May or may not make it more expensive. That was a long answer, but you're gonna get that from all the lawyers who are nervous because we did them because they've been around since 2008 and that case came out about 5 years ago. So not good, and that's why you should use a trust instead of a TOD deed.
Very interesting, huh? Do we have another question? We got one up in front here, Larry.
Do step-grandchildren that reside in another country and are not citizens of the U.S., do they have the same equal rights as step-grandchildren here?
So the question is about foreign nationals. You know, what if the beneficiary, regardless of how they're related, do they have the same rights as somebody who lives here? And the answer is yes. They have the right to inherit property. We send money overseas all the time. But be careful. Here's why. So I'll tell you a story. Sorry to tell a lot of stories. All right, so about 10 years ago, I had a client in Omaha. We have offices in Omaha and Grand Island as well. I'll be in Omaha all day tomorrow. And she was terminal with cancer. She knew she was going to die. Her only beneficiary was a daughter who lives in Saudi Arabia. She had met her husband, who's a Saudi national, in college. And he was not a religious Islamic type. He was very secular himself. But that doesn't matter because in Saudi Arabia, it's Islamic law. And when a woman inherits property in Saudi Arabia, where do you think the property goes? That's a good guess. The guess is the husband. Actually, no. In Saudi Arabia, under Islamic law, if a woman inherits property, it goes to her father-in-law. Can't make this stuff up. And to his credit, her father-in-law, Saudi national over there, said, tell your mother this because I have no choice. If you inherit, it is a sizable estate. If you inherit that estate, I have to take it, and I don't want to. That was very nice of him to do. So we hurried up. We did a trust in Omaha with another trust company, and it worked. She died. All of the sizable estate is in a trust with the trust company in Omaha, and once a year, they come over here, they get reimbursed for their expenses, but she doesn't own the property, it's in a trust for her. So we cannot control the laws of other countries. Most Western nations have tax treaties with us. If it's a British Commonwealth country, don't worry, because our laws are based on Mother England, so it's the same law, Canada and Australia, but it's interesting. Different countries have very different laws.
Yeah, that is interesting. Okay, well, for panelists, do you guys have anything that you'd like to add? Any comments, anything to wrap it up? Anything that we didn't get covered that you make sure you want us to know?
Boy, I think we've covered a lot of ground today.
You did good.
We just appreciate the opportunity to be here today and to present and answer questions. And from Doug and I know Andrew's standpoint, we're here as a resource for you, and we want you to feel free to reach out to us and ask any questions.
Great. Thank you so much for being here. We really appreciate it. Let's give them a hand. Thank you so much. Great information.
And we love your name, Savvy Seniors. That's cool.
Thank you. We're all savvy.
She just was gonna make a comment. When they your family or whatever, it's in that bottom drawer. We also need to keep a copy of our passwords with it in that bottom drawer.
That's for sure.
Yeah, so keeping passwords available, and one of the things that we tell our clients is it's important to be, digital assets are such an important aspect of people's estate plans, and they will continue to become even more relevant. One of the things that we offer our clients is if you write your passwords down and you seal them in an envelope, write your name and date across the back of it, we'll put them in our vault along with your original documents. We don't open them. When you come back in, we give that envelope back to you so that you can see that they haven't been opened. But again, we become detectives when somebody passes away, and how do we locate those statements that you get from your investment officer only through your email? You no longer get a paper copy. So those passwords become very, very important.
Good point.
Great point. Okay, we got one more, real quick.
I found a resource that helps with that called the Knock Box, NOK for next of kin. It's a package they put together. They are out of Colorado, and they did that. It's a kit to keep track of all of the important papers and passwords and keys to safe deposit box and all that stuff.
Okay, great. Well, what we have handed out to you is an evaluation of our seminar today. We don't ask to pay for anything, everything is free, but we would like you to give us a really good evaluation. Tell us, what you like, what you don't like, how we can improve. And if you'd like to make an appointment with any of our educational partners or anybody on the panel, and you want us to make sure that we help you do that, we can relay that information on to you. We don't give out your information to anybody, that stays with us. But if you fill that out, and for those of you that fill that out completely, our educational partners have brought some door prizes, and we'll have a drawing for that. And so go ahead and fill that out, and while you're doing that, I just want to mention our next Savvy Senior Seminar that's coming up in January is going to be a little bit different. We're going to start out the year with something fresh and something fun. We're going to talk about how we can squeeze the most out of life as we age to 100. We're going to have some people talking about happiness. And we're going to have some people, actually Bill Craswell, who's heard Bill Craswell here? He's actually a relative, and he's going to be here, and he goes around to a lot of different senior living communities and spreads joy, and he volunteers, and he's going to talk about why he does that. He might even sing us a song or two, and then we're going to have actually some experts on how to maintain your happiness and get the most out of life. So that's going to be our January seminar. Make sure that you come to that and you bring a friend. And something different that we're going to start in January is we're going to have a special drawing for anybody who does bring a friend who hasn't been here before. Their name will go into a special pot. So we appreciate all of you coming today. We appreciate all of our educational partners who helped us sponsor this and put it on. And we thank Susan for the awesome job that she does with Suite 111. I highly recommend if you have a wedding or any kind of an event, give her a call, because she is the hostess with the mostest, and she's really sweet about it. So thanks for coming today. And George and Dave will pick up the evaluations, and we'll have a drawing. And there's some really good stuff I've been seeing. And we're going to let our panelists draw the winners. They're going to make some friends today. So I think we have 1, 2, 3, 4 door prizes to give away today. Barry doesn't get one.
Yeah. Doug's got to go to a board meeting.
Thank you so much, Doug. Okay. Lay these down here.
Okay.
We got some more coming up here too. No peeking, Andrew.
There's another one.
See that one? Got a couple more coming back there.
Yeah, you are. Hands down.
You guys did a great job. Thank you so much. Wonderful.
Yeah, she's going.
Okay. So we've got several to choose from here.
We're gonna let Leslie do
Okay. She is a trust officer. She can be trusted. Okay. All right, so we'll just go ahead and start with Lucky Dog Property Solutions drawing. Who's the winner here?
Carol?
Carol.
Yeah.
Okay, so you want to go back there and talk to AJ and get your prize. Who's the next one? We will have Stay Home Cares prize.
Susan Tribby.
Who is that?
Susan Tribby.
Susan. Okay, great. And then we have one with Alzheimer's Association.
Michelle Scala.
Michelle Scala. Great. And then we have one from American Senior Benefits. Who's the winner for that?
Is it Wallace Blunt?
Wallace. Wallace and?
Wallace and Blunt.
Okay. Great. Congratulations, all of you. Thank you again to our wonderful panelists for coming here and spending this time with us. I know your time is valuable and important, and we truly appreciate you being here. Thank you.
Thank you. And Larry was here.
Yes, Larry too.
What's your easiest day of the